with this material, I move headfirst into the law of real property. And as I have discussed with you previously, property law is the law of value. Property law is a substantive area of law that articulates the rights that we have to things of value. By having a law of property, we wish to make it easier for us to transfer interests in property and prove that we own property. We wish to be able to allow for government to tax property easier. One of the objectives, certainly, of the law of property is to provide a means by which, if there is loss sustained, that there can be a claim upon insurance for that loss. When someone has an interest in an asset and they die, we recognize that certainly they can't take that interest with them. And so what's the means by which that property will be passed along and to whom that property should be passed? Those are amongst the topics that are answered when we understand the law of property. And so with these lectures, my objective is to give you a working knowledge of, a sense of, an understanding of the law of property. And I'm quite confident that this will be important to you in the years to come. And it will culminate actually with me giving you an overview of wealth transfer at the time a person dies. Not something that we certainly look forward to, but is certainly part of life and things that you will go through with family. And I think, again, having a certain understanding of the law of property will help you navigate those times when they are present in your life. And so without further ado, I'm going to go to the lecture slides, and I'm going to try to explain the concepts of property law, focusing in with this and our next asynchronous lecture on the law of real property. And of course, we start with an understanding that anything that has value to it is considered to be property. And we divide things that are of value into really two categories. The first category being real property, and the second category being personal property. Real property is the land and anything that is permanently attached to the land. So Mother Earth, if you will, and anything that has made a permanent structure upon the earth. So a building, a house, an apartment complex, a farm, house, any structure to which we would have to either tear into the earth or tear down the structure to be able to actually move the structure. And this is compared with that which is considered to be personal property, which is moved upon land. And so what you're perhaps wanting me to distinguish is the difference between a house and, say, a modular or mobile home. A mobile home, a modular home, something that is built other places and then constructed upon land, is still considered to be personal property. Whereas when you have perhaps the home that you were born in, or the apartment or condominium that you live in, or even the place upon campus that you're attending class, or the dorm building that you are in, that's a permanent structure that would be covered by the law of real property. And this distinction between what is considered to be real property, the land and that which is permanently attached to it, and personal property, is a very important distinction within the law, because so many of the questions that I raised a moment ago that is covered by the law of property is answered largely based upon, is your interest in property a real property interest or a personal property interest? Because how we go about transferring property differs if it's a real property interest as opposed to a personal property interest. How we go about taxing property is different if it is a real property interest in land as opposed to a personal property interest in land. How we go about repossessing property, if someone has a lien upon property, differs if it's a real property interest as opposed to a personal property interest. The very nature of ownership differs if it is a real property interest in land as opposed to a personal property interest in land. Everything that is an ownership interest in real property is a matter of public record. You can look up who owns every square inch of land in the United States of America. It's a matter of public record. We transfer ownership interests in real property through the utilization of a government office known as the Register of Deeds office, wherein there isn't a governmental repository, if you will, for the ownership of personal property. We may register a vehicle. We may register intellectual property. Certainly, we may file a tax return and represent that we own a particular bank account with a number that is assigned to us. But there is no public record of who owns what personal property in the manner upon which there is a public record of who owns land, who owns real property. What happens to property when someone goes bankrupt differs if the interest is a personal property interest as opposed to a real property interest. What happens to property at our death and to whom and how that property is transferred differs if it is a real property interest as opposed to a personal property interest. So this distinction, the distinction between real property and personal property, very, very important to grasp right from the outset. And it's not complicated. It's not difficult. Property Law 101, the first day of property law in law school. What's the difference between real property and personal property? And it begins with understanding that real property is the law that applies to the land and anything permanently affixed to the land. Whereas personal property is what we describe as being anything of value that is not considered to be real property. In fact, that was probably the first definition in law school that I actually understood. Personal property. Everything of value that is not considered to be real property. Now, within the law of personal property, we subcategorize the law of personal property into different types. We have tangible personal property, stuff that we can pick up and move and acquire and give away. And then we have intangible property. We think of money and stock as being intangible personal property, but certainly intangible personal property with value. One of the things that I would always do when we were physically together in a classroom is I would always select someone in the first row and I would hold out two pieces of identical size, if you will, almost identical looking paper. And on one of those pieces of paper, there would be a 1 on it, and it would have a picture of George Washington. And on the other picture, there would be a 5, and there would be a picture of Abraham Lincoln. And I would give the student sitting in the front row the opportunity to select one of those pieces of paper that he or she wished to keep for himself or herself. And every single time I have ever made that offer, the student has always selected the paper with the picture of Abraham Lincoln on it and the five. Um, and I always have thought to myself, what do people just not like George Washington? Obviously, we recognize that a $5 bill has greater value than a $1 bill. But it's not because of the paper or the color or the weight. It's the fact that we denote the five and the president of, or the picture of President Lincoln as representing $5 of currency as opposed to only a single dollar of currency with the $1 bill. And you can see where then intangible property can have value associated with it based upon what we associate in our minds with some aspect of that intangible property. We will look at, as part of our overview of personal property, the law of intellectual property, copyrights, patents, trademarks, trade secrets. I think it is important to have a working knowledge and understanding of how we go about securing ownership interest of an intellectual nature. What is it about that piece of fruit, that apple with a bite taken out of the side of it, that we see on our phones and our laptops, and even on the television programs that we watch? I admit I'm kind of a Ted Lasso fan. What is it about that bite of apple that we associate such tremendous value toward? We have value in the identity, if you will, of Sparty, that people see and immediately associate with our university. All of that comes under the subcategory, if you will, of intellectual property that is part of personal property, something of value that is not the land and that which is permanently affixed to it. But from this point forward in this asynchronous session and in our next asynchronous session, the focus is going to be upon the law of real property. And we begin our overview of the law of real property by understanding that land, the law of real property, ultimately flows through to private ownership, starting with that property interest being first and foremost something that the government has owned that then is oftentimes transferred into private ownership. And one of the distinctions between the law of property in these United States from property in other countries, noteworthy amongst them China, is that once property is transferred by government into private ownership hands in the United States, the presumption is that that ownership interest will remain in private ownership hands, whereas in China and in other countries, ultimately the ownership of land will revert back to the government. One of the values certainly associated with the United States, the creation, establishment, if you will, of the United States, the ratification of the Constitution, the expansion of the country, is we have had in North America, we have had as part of these United States a lot of land. And that land has proven to be of great value in the growth of the nation. And when the country was formed, when the Constitution was ratified, when the United States government came into existence, there was the need for taking this land that the United States government owned and trying to monetize. the land. There was debt associated with the War of Independence that had been fought. There was debt associated with the attempt to operate a national government. And there was a determination made by the founding states that, unlike land descriptions in many European countries, in the United States, we wanted to be able to transfer interests in land without gaps in the ownership of land that can oftentimes exist when metes and bounds descriptions are used to describe land. And so Thomas Jefferson was tasked with the responsibility of coming up with the means by which we could actually survey and describe the location of land. And Jefferson, in association with a number of other intellectuals at the time, developed a unit of land measurement that we still use to this date in the United States, and that is the division of property into what are referred to as townships. And most townships in the United States are units of land that are divided into 36 square sections of land. So a township typically will have 6 miles east and west, 6 miles north and south, made up of 36 square sections of land, square miles within those sections. And it allows for a detailing with accuracy the location of land within the country, and certainly within a state, and then within a county. If you take this lecture slide by way of example, we divide the state of Michigan, as most states do, into a meridian, which cuts the state into a east and a west, and a baseline, which divides the state into a north and a south. For those of you that are certainly familiar with the mid-Michigan area, you perhaps have gone out to the Meridian Mall, or you've traveled out to Williamston, and no doubt you have crossed Meridian Road. That's the road that divides the state of Michigan into a north and a south for purposes of legal description. And certainly those of you that are from the Detroit metropolitan area are very familiar with Baseline Road, also known as 8 Mile, which actually divides the state into a north and a south. And from the meridian and the baseline, or the intersection of the meridian and the baseline, what you see on this lecture slide, or hopefully what you see on this lecture slide, are a collection of very small, blue, rectangular shaped areas that constitute townships. And if you were to take a legal description of land, and I were to tell you, go find land that is located, 10 townships north and 10 townships west, you would go to the intersection of the meridian and the baseline, and you would count up 10 boxes to the north, and then you would count over 10 boxes to the west, and that would put you into the township that I am trying to direct your attention to. And then what you find is that once you are at the correct township, that all townships then are subdivided into sections. And the typical township has 36 sections, each section being, as I mentioned, 1 square mile, or if you will, 640 acres. And what we do with the description of property is we take the numerical designation of each section within a township, and we repeat it with every township. So section 1 is always in the upper northeast quarter or northeast point, if you will, of a township. And section 6 is always in the upper northwest portion of a township. And you see sections 21 and 22 and 16 and 15 concentrated right in the middle, if you will, of a township. And for those of you that travel on the back roads of the state of Michigan, what you'll typically see in sections 21 and 22, and it makes some sense, is that's where you'll oftentimes see the old schoolhouse located for a particular area, because they wanted to make it as centrally located within a township as is possible. Or that's certainly where you'll see the township hall for a particular community. To the right side of this lecture slide, you will see within each section further possible subdivisions of land. If you, by way of example, are transferring land, or you are looking to find land in the northeast quarter section of a particular section, that's denoted in the box that you see in the upper right-hand side of this lecture slide. And when we transfer land, we do so, and certainly when the government transfers land into private ownership, that transfer takes place in the form of a legal description that utilizes the concept of the rectangle and square descriptions of land, so that there is never a gap in who actually owns property, as is the case in many European countries. One of the reasons why this is the system that was employed and to this date utilized is that much local government is actually funded through taxes on the ownership of real property. And what the government always wants to be able to do is know exactly who owns real property, and doesn't want there to be any dispute over, and wants to be able to maximize the land by not having gaps in property. And this is a means by which we ensure that there won't be gaps in who is responsible for taxes, as there will not be disputes over who actually owns land. Now, what will happen within communities, particularly as they continue to develop, is you will have a developer, someone that will go in and buy up land and record what we refer to as a plat. And that plat will take property and then further divide or describe the subdivision of land into what we refer to as lot descriptions. So you may have parents, or you yourself may own land that is described as Lot 1 Elmwood subdivision, Meridian Township, Michigan, by way of example. And behind that lot description always is a detail of where that lot in that subdivision is located within a particular township. With mathematical precision, certainty, we can always detail who it is that owns property, and it is always a matter of public record. What we do is we typically take the township and combine townships in numbers of anywhere between about 16 and 24 to form a unit of government that is known as a county. And county government is a means by which we are able to combine resources for purposes of having courts, having sheriff's departments, paying for government operations like roads, and as will become increasingly important, the maintenance of roads. So we have township police departments certainly as a possibility. We may have township government as a possibility, but we will always have county road commissions and county courts and county sheriffs, which will be comprised of a combination of anywhere from 16 to 24 different townships. We'll have a county prosecutor. But one of the important county officials will be an official that is known as the County Register of Deeds. And the Register of Deeds in most states, certainly in Michigan, is an elected public official whose responsibility it is to track the ownership interests in land within the townships that exist within that county. I will show you as we progress through our overview of the law of property, how you have the ability from your computer to actually look up and track the ownership of all land that exists anywhere in the United States. And it's done because the tracking of land is the responsibility of a government official known as the Register of Deeds for the county within which the land is located. This is the law. This has always been the law. This will always remain the law, really for two reasons. One, it allows for government with assuredness to know who is responsible for paying property taxes. But also, one of the functions of government historically has been to minimize, if not reduce, disputes over the ownership of land. We do not want there to be ever a question about who owns land. And so we want there to be a method, a system, whereby ownership of land is transferred with certainty from one owner to another, allowing for someone to borrow money and use as security land. And the government plays a vital role in tracking the ownership of land so that there won't be disputes as to who owns land, and even whether someone who is purporting to sell land actually owns an interest in land and is able to actually convey that interest in land to a purchaser. This lecture slide shows kind of an antiquated way of tracking land within a county. These are what are called LIBOR books. And if you go to the county courthouse, you'll see an office that is known as the Register of Deeds office, and you'll usually see, on the walls, large books in which the ownership of land will have been tracked in these LIBOR books historically from the very beginning of the township, or from when that township came into existence. Now this is all done in a much easier format through electronic means, through digital recording of the ownership of land. But again, it's done with precision so that we will not have disputes over who actually owns land at a particular time. And it's this government's involvement and the purpose behind this governmental involvement that allows me to, again, with great certainty, say to you that it is always possible to know exactly who owns every square inch of land, what they paid for it, what the taxes are that are collected for ownership of that land each year, whether those taxes have been paid, even whether or not someone has borrowed money and had a lien placed upon the property in the form of, say, a mortgage, all a matter of public record, all something that I do want you to have the ability to do for yourself, because it is a skill set that is not complicated to acquire, but I think will prove valuable to you in the years to come. Now, recognizing what real property is, It's the law of the land, which covers the land itself and anything permanently affixed to the land. And recognizing that ownership of land is always a matter of public record, that the Register of Deeds office tracks who owns land, and every time there is a transfer of ownership of land, the transfer of that ownership of land is memorialized at the Register of Deeds office. We next turn to a very important concept wherein we look at the interests that can exist in land. And I want you to think about yourself for a moment. Many of you right now have a lease agreement with a landlord. Many of you have an apartment that you're making payment on. Many of you are renting a house. Some of you are living in dorms where you are paying the university to reside. All of you are living someplace. Some of you are fortunate to be perhaps living at home with family members and not actually making payment. But I suspect that most of you have what we refer to as a lease arrangement with some landlord providing you housing. That lease agreement is a property right that you have. You cannot be thrown out into the streets. You cannot be thrown out of your apartment or your house without being afforded due process of law. If you stop making payment, and this is not a suggestion to you to stop making payment, but if you stop making payment to your landlord does not get to come and just take you and throw you out on the street. Your landlord has to first go to court and obtain an order of eviction before you can be thrown out on the street, because your interest in that apartment, in that room, in that house is a property interest that cannot be taken from you without first giving you the opportunity to be heard, without having what we refer to as due process before that property interest is taken of you. But you don't own that apartment. You don't own that room. You don't own that house. You have an estate. You have an interest in that land without owning. An interest in land may be an ownership interest in land, but it doesn't have to be an ownership interest in land. It may be what we call, in your circumstances, a leasehold interest in land. You lease the property that is actually owned by someone else. Whenever you have an interest in land, that interest in land is said to be an estate in land, E-S-T-A-T-E. An estate in land is something that we have if we have real property to which we hold a right to. There are 5 estates in land, and the only way that I can make this easier for you is to tell you, you need to know all 5 estates in land. You need to become familiar and comfortable with the terminology of the estates in land. And there's nothing complicated other than it's probably a term that you don't use a whole heck of a lot. When you think of your apartment, when you think of the house that you are renting, you probably don't think of it as an estate in land, but it is. It's a leasehold estate in real property. If you picture a pyramid, and at the bottom of the pyramid, if you will, you have the most significant part of the pyramid. And at the top of the pyramid, you have probably the least or less significant part of the pyramid. That maybe is a way of thinking of the estates and land. The most consequential estate and land is what is known as the fee simple estate. The perhaps least consequential estate and land is what we refer to as an easement. That would be at the top of the pyramid, whereas at the bottom of the pyramid, the most consequential, biggest, broadest, most significant estate and land is what is referred to as a fee simple estate. There's two terms that I wish to define for you as we talk about the estates and land. The first term, and you've heard me use this word before, is title. T-I-T-L-E, title. Title is really just a fancy legal way of saying ownership. If you hold title to something, you hold ownership. Now, we use the term title because usually the more valuable something is, the greater the likelihood that you'll be able to prove ownership by showing a title. Here's a piece of paper that proves this property belongs to me. We have that with land when we take title through the form of a deed or a court order. We certainly see that with motor vehicles, when proof of ownership is in the form of a paper title that describes the vehicle and the identification number associated with the vehicle and hopefully places our name on that title. The more tangible an asset, the greater the likelihood that there won't be a title that exists. People have their clothing, people have their television sets, people have their laptops, people have their sporting apparel and equipment, and typically they don't actually have documentation that proves ownership. Maybe they've got the receipt, but there's not a paper title associated typically with tangible things of that nature. But for our purposes, title denotes ownership. Title is a synonym for ownership. The other term that I wish to make sure that you grasp at this point is possession. What is it to possess something? Under the law, to possess something means that you have the right to use it and to exclude others from the use of that which you possess. So for the time being, when you're renting an apartment, when you're renting a house, when you're renting even a room in the dorm, you possess that estate, you possess that real property, you possess that land for a fixed period of time. Now, that possessory right may be joint with others. That possessory right may permit the landlord or owner to come in and inspect the property. But if you're at your apartment and at 3 o'clock in the morning, somebody comes banging on the door and says, "Let me in," you have the absolute right to say no, because you possess that apartment. Not all estates are possessory estates. An easement, by way of example, is an example of where we have an interest in land that is not exclusive. It's a non-possessory estate and land. Others have the ability to use exactly what it is that we have the ability to use. So what are the estates and land? The estates and land are the descriptive terms for whenever someone has an interest in land. Any interest that exists in land is considered an estate in land, and there are 5 of them. The first estate in land, the most consequential of the estates in land, the most significant estate in land, is what is referred to as a fee simple estate. This is absolute ownership of land, subject only to the limitations of use of land that are established by law. It's the most common form of ownership of land, to own the land in fee simple. Most of the time when you acquire land, you will acquire land in fee simple. The ownership of that land is yours. It may be yours subject to the payment of a loan. It may be yours with others, but it's not going to revert back to the government, i.e. what happens in China. And it is yours to do with it what you want, so long as you don't use the land in violation of the law. Contrast the fee simple estate, absolute ownership of land, with the next estate in land, which is referred to as the conditional estate in land. A conditional estate in land is absolute ownership of land, but subject to some conditions, some limitation on the use of land placed upon the land by a prior landowner. I was involved in a sale of land some years ago, wherein the seller of land wanted to make sure that the land was only going to be used thereafter for residential purposes. They wanted to make sure that there weren't going to be any businesses operating in the area of land that was being transferred. We sold the land subject to the condition that the land could only be used for residential purposes. The concept of the conditional estate is lawful, but very sadly, it has a history of being used for really immoral purposes. Historically, conditional estates were used to segregate the living upon land based upon the color of a person's skin. This was a common way that landowners would transfer land and limit who could actually live upon the land from that point forward, again, based upon the color of a person's skin. Fortunately, by the 1940s, most states had abolished allowing conditions of land to be used based upon racial or color lines. And certainly by the passage of the Civil Rights Act of 1964, it is unlawful to place as a condition on the use or occupancy of land a limitation based upon the color of a person's skin. But it is important to understand that this is a way upon which people historically have tried to place limitations on the alienability, the use of land based upon factors that, again, are no longer permitted, but I think do illustrate how conditional estates have been used historically. One of the conditions of property that I remember running across as an early in my years of practice was how men in particular who owned land would transfer the land that they owned at the time of their death, but subject to the condition that their wife not remarry. These conditions of title also have been rendered unlawful in violation of public policy. But they existed, and I remember running across them. I had a case not that long ago in which a man in his will left his farm to his 5 children. I didn't draft the will, but the man leaves the farm in his will to his 5 children, A, B, C, D, E, but subject to the condition that E would only get her share in the land if she would divorce her husband. Now, her husband and she had been married at that point in time for 29 years. But boy, obviously that father-in-law didn't like his son. Now, when the farmer died, that condition was rendered unenforceable in violation of public policy by the court. So conditions placed upon property have to be for a purpose that is not unlawful. But there still are conditional estates, and particularly in the hospitality industry, it is important that businesses check the title of property to make sure that there aren't restrictions on the use of property placed upon the property by a prior property owner. This is different than lawful distinctions or limitations that may be placed upon property. There are limitations built in the law of Michigan, by way of example, that you can't sell alcohol within 600 feet of a school or a church. That's a statutory limitation on the use of property. That's not a conditional estate. You will have zoning limitations, and we'll talk about zoning as we move forward, that will restrict the ability for somebody to engage in certain property or use of property. That's not a conditional estate. A conditional estate is a lawful limitation on the use of property in the future placed upon the property by an owner of that property in the present. Most states have what are known as 40-year marketable title acts. And in Michigan, you have to go back and look at title for the 40 years pre your use of the property to check if there are any limitations, any conditions placed upon the use of that property. The life estate is one of the more unique estates in land in that a life estate is the use of land for the duration of one's lifetime, but not ownership. You actually have as a property right the ability to use land for the duration of your lifetime, but you don't actually own the land. This is a device, this is a concept that has been used historically for estate planning purposes. As we sit here today, the federal estate tax threshold is well north of $11 million per person. That's a lot of money. Most people don't have anything close to that. But back when I entered into practice, the federal estate tax threshold, 1991, was $600,000. And there are a lot of people that have $600,000. What people would do so that their estate would not be subject to as much tax at the time of their death is they would oftentimes give away land prior to their death, but retain for themselves the right to use the land for the rest of their lifetime. And this would be a life estate. I give my home to my children, subject to the right of me living at my home for the duration of my lifetime. They own the property. I have a life estate, the property. It was used primarily for estate planning purposes. It still is. You'll have older people. They will get married, or perhaps they will choose to live together, and they come to that relationship already with children and already with money and already with a desire to leave their assets to their children at the time of their death. But they want to buy a condo or a home with their significant other, their spouse. She puts up half of the price or pays half of the value for the condo. Spouse does the same thing. Each of them takes a half interest in the condominium, and they give each other a life estate in the other half interest in the condominium. First of them dies, the condo interest that they hold passes to their family, but subject to a life estate in the surviving spouse. It forces the family to wait until the surviving spouse or significant other dies to be able to sell the condo and reap the benefit, but it protects the spouse from being forced out simply because the first spouse has died. The next estate in land is what is known as the leasehold estate. I talked to you already a little bit about the leasehold estate. It's an interest in property. It's an interest in real property, usually subject to a contract, but it's for a limited period of time. I know that you probably think of your lease as debt because you had to come up with payment every month, but actually the law views your lease as an asset to you as the tenant. You cannot have that property interest. You cannot have that land taken from you without due process of law. You possess that property for a limited period of time. You have the ability to control, to use that property and exclude others from the use of that property, but only for a limited period of time. You don't own the apartment. You don't own the house. You have a leasehold estate. Someone else actually is the owner of that property. The fifth and final estate in land is what is known as an easement. An easement is the right to use property of another, but not exclusively. All property typically has multiple easements affecting that property. We have utility easements, we have access easements, we have rights of way. An easement is something that benefits a particular parcel of property by allowing the occupants of that property to use an adjacent property for a particular purpose. Let me give you an example. At one point in time, parcel A and parcel B were probably all part of what we would refer to as one parent parcel. There was one large description of property, and it was inclusive of all of the property that you see on this lecture slide. But at some period, a developer went in and said, you know, we can maximize the value of this land by dividing the property into parcels and selling off the parcels. And so the property was divided into a lot A and a lot B. And lot B was sold by the developer. But access to lot B requires someone being able to drive across lot A to get to the road. Because if you can't get to lot B from the road, if the only way to actually get to lot B is somehow from the air, then lot B would be what we call landlocked, and it would be ostensibly valueless. Hey, there's a piece of property over there and I own it. Unfortunately, we can't get to it. Well, the law is not crazy. the law allows for the division of property to include the right of access to that property. And so when property B is subdivided from the larger parcel of property, the owner of parcel B, in addition to owning parcel B, will also have transferred to the owner an easement across parcel A. And this is an estate and land. It's not a possessory estate because it's not exclusive. Obviously, other people can use and do use parcel A. But what that easement does is it prohibits someone from blocking the easement. So you see up at the north side of parcel A, that strip that allows for the occupant of parcel B to get to the road to the east of parcel A. What the occupant of parcel A is not permitted to do is put a fence up or block that easement, prohibiting ingress and egress, access to parcel B. We see this with access to lakes, particularly in farther north that you go in the state of Michigan. And what is very important to understand about easements is that the easements run with the land. They stay with the property. The owner of parcel B dies. Someone who never even met the owner of parcel B comes and buys the property from the estate of the owner of parcel B. The easement remains with parcel B. The new owner has the property taken from him through a foreclosure, and now the bank owns the property. The easement remains. The owner of parcel A moves away or gives the property away. The easement remains. The only way that you could ever destroy the easement would be by agreement between the owners of parcel B and parcel A. And why would parcel B ever, or the owner of parcel B ever agree to extinguish the easement? Because again, it would render the parcel so much less valuable. We're going to move in the next asynchronous lecture to talk about how interests in land are transferred. All interests in land are comprised in the description that I have just gone through you, the estates. It is very important that you understand that any interest in land is in the form of an estate in land. Any ownership interest, any possessory interest, any right to land has to be framed as being one of the 5 estates in land. And as you certainly can see, when you look out onto land as you're driving through East Lansing, driving home, or driving up north, and you look about you and you see Mother Earth and you see buildings and structures and homes and condos and apartments, recognize that there are likely multiple estates covering that same property at the same time. Somebody that owns the property, perhaps someone that has a life estate in the property, someone that is leasing the property, and some adjacent property owner that's got an easement to be able to use that property non-exclusively. I think that's good for our first overview of the law of real property. The good news about the law of real property is that it is the least subjective area of law that we have. If torts were the most subjective area of law, we follow that up with the least subjective. This is the topic that more students ace, get 100% than any other topic in the course. because there is absolutely always uncategorically a right answer when it comes to a property law question, because those questions all get back to the issue of who owns it, what interest do they have, and all of the ancillary uh, discussion points about the law of real property. Keep well, look after yourself, both physically and mentally. Reach out if there's anything that I can do for you, and go green.